everyone, and welcome, and thank you for joining us today for our webinar this week, where we're going to take a short pause on the COVID-related matters and dive into our new and improved data privacy and security law, SOPA, or SOPPA, depending on how you want to pronounce it. We know in the midst of this unprecedented year, you are now trying to also come into compliance, be ready for our July 1st implementation date for SOPA. We're happy to be with you today to try and navigate through some of the more complicated compliance issues you're all facing with this law. I'm Nicki Bazer, and I'm joined by my partner, Jackie Wernz. No doubt many of you have spoken to both of us over the past few weeks and months about SOPA. We're going to be going through a number of the questions you all have raised during our conversations, questions that have come in before the webinar. And please, if you have any questions while we are doing this, feel free to submit them. If you do have questions, please submit them through the Q&A function on Zoom rather than the chat. It's easier for us to monitor that. We'll do our best to monitor the chat if you put things there, but if you can go into the Q&A, that's the easiest. We'll do our best to answer all of your questions, and please make sure you sign up for our Franczek alerts. We do send out data privacy information over our alerts as well. You can always email us at events@franczek.com to get signed up, or do so on our website. Once signed up, you will receive notice of our weekly webinars, which are held on Thursday at noon. All right, so with those housekeeping details out of the way, we're going to jump right in. We have promised that this is going to be a bit of a higher level discussion today, or in some ways more in the weeds on SOPA, but I think we should start with the basics. So Jackie, maybe you can start us off with what is SOPA and why are we talking about it right now?
Yeah, so hi everyone. Thank you so much for joining us. And we do see the registration list and we see the participant summary of who's on here. So we know that many of you could be up here presenting with us on this topic. So we certainly don't want to dwell too long on the basics, but we did just want to start out with a little bit of a background in case we do have anyone here who is coming to this for the first time. So the Student Online Personal Protection Act, which is SOPA or SOPPA, is the data privacy law in Illinois that regulates student data collection and use by schools and the Illinois State Board of Education and education technology or ed tech vendors. And it became law in 2017 after years of negotiation between stakeholders and legislators. Fun fact, I actually got to know Nicki through those negotiations when she was at the State Board of Education and I was at Franczek working on behalf of some of our associations. So she and I have been in the trenches on this together for quite some time. But then the real reason we're all here, as I know many of you know, is that in 2019, we got an amendment to SOPA. So a new version of SOPA that gives a lot of new mandates, requirements, rights to parents and students. And that law becomes effective on July 1st of this year.
Yes, we have been dealing with this a long time, and I guess the one thing I can say about SOPA is that it's better than some of the previous versions of laws we saw. So that's about all I can say to endorse it. And obviously, we do take data privacy and security issues very seriously. So I do think the focus on school district implementation has really been about that. So certainly a good focus and a good cause. So Jackie, maybe you can also take us through what are these amendments that go into effect, again, in brief, in July that school districts need to be concerned about, and then we'll talk a little bit about each of them and some bigger picture issues.
Great. So yeah, so one of the biggest things is there are a number of posting requirements. So you need to be posting annually the operators, the subcontractors, and the applications that you're using. You need to be posting annually the data elements that you're collecting or maintaining or disclosing and how you're using the data. You have to post within 10 days of signing an agreement with an operator as defined under the law. You have to post a copy of your contract with that operator on your website. And then there's also a parent notice that is an annual thing that's required. And Nicki, you can maybe give us a little more detail on this, but ISB has adopted the IASB notice for parent notice. Is that right?
Yeah, that's correct. So ISB came out, I think it's Exhibit 2 to their SOPA policy, which is 7345. And so that notice is pretty straightforward. And you can get, if you are not a press district and don't have ISB services, on ISB's website, it gives you the email address of someone at ISB to contact, so you can get a free copy of that notice.
Right. So the postings, that's a big part of the law. And then there's also some new regulations around the contracts themselves. So for example, you're now required to have a policy like the one that IASB just came out with. You're required to have a policy in place. It needs to address who can sign contracts with operators. You need to decide whether you're going to designate a privacy officer to ensure compliance. And spoiler alert, I think that Nicki and I both believe that you should, that this is a good thing to do, even though it's not required by the law. And then you're also required to maintain reasonable security procedures and practices. And again, ISB's expected to provide us some more guidance on that, although we don't have it yet. And so that's really the 30,000 foot summary of what SOPA requires. But if anybody wants us to dig in any deeper on any of those requirements, please don't hesitate to pop a question in the Q&A and we'll be happy to answer it. And send us all your questions in the Q&A. We're happy to have you guys direct this conversation a little bit. But I do want to say that we know, and when we say that we've been talking to a lot of you, one of the things that we've been talking about a lot is getting these data privacy contracts signed. So Nicki, let's talk about the ins and outs of the Ndpa and what we're seeing in terms of issues around that.
Yeah, absolutely. So just to orient ourselves, and again, I know a lot of you are in the trenches on this already, but for those of you who are not, so, we have always recommended that districts sign data privacy or data sharing agreements, DPAs, with vendors where you're sharing student information. And for a lot of years, Jackie and I had created sort of a template addendum. We have updated that for SOPA purposes, and some of our districts are using that as their sort of template SOPA addendum or agreement. But I think more common, and rightly so, is the use of what's called the National Data Privacy Addendum. And what the Ndpa it was created a couple of years ago by a national consortium. And the idea behind it is to have a standard agreement that vendors can sign on to, and that then other school districts, so if school district A signs an Ndpa with vendor one, then school district B can just piggyback onto that agreement. They don't even have to work with the vendor. They can just sign on to that same Ndpa. One of the elements of the Ndpa also is a exhibit that is for state specific provisions. So in our case, Exhibit G has all of our required SOPA provisions that don't already exist within the Ndpa. So there's some stuff in the Ndpa that is consistent with SOPA, and then Exhibit G just sort of adds on to that. And I was fortunate enough to serve on a committee that helped amend Exhibit G. So some of you will be familiar that there was a version 1.0, and now there's like a version 1.A, I think it's called, which is the amended Exhibit G. Well, they're fine, but I think the second one is probably a little bit cleaner. So that's the Ndpa. It's a great idea. I think what we are finding, though, is that there's also this thing called Exhibit H, which allows actually either side to add additional modifications to the Ndpa. And what we are seeing is that a lot of vendors are taking full advantage of Exhibit H and adding a lot of modifications and different provisions into the Ndpa itself. So when you are signing on as the originating district or you're piggybacking on, you're seeing these amendments. And Jackie, I know you've been looking at these as well as I have.
Yeah, and some of the things that we're seeing there are like, limitations of liability, or statements about how a vendor can use de-identified data. So those are a couple of examples. But I do think, when I was thinking about this and in preparing for today, I was sort of thinking about how do I feel about this Exhibit H and about the Ndpa generally. I mean, I will say anything that I sort of think it like insurance, like my husband's always telling me, stop buying those little $3, insurance things whenever you buy like an electronic, because he's like, if somebody's selling it to you, it's probably not worth anything, Jackie. So stop wasting our money. And I sort of feel like with the Ndpa, it is something that the vendors really were behind. The vendors really like it because it makes their life a lot easier. I wouldn't say it necessarily makes school districts' lives easier, because you still then have to deal with Exhibit H, and you also have to think about, you're entering into a contract with a vendor, period, not just a student data vendor, but they are a company that you are entering into an agreement with. And Nicki and I, we do a lot of reviews of contracts that don't have anything to do with data. And there are lots of provisions in there that we change, or that we say to a district, it's really risky if you agree with this. So in some ways, I think the Ndpa could be a little unfortunate for school districts, even the ones who are the ones negotiating the first one with the company. But then for those who are later on down the road, who are piggybacking on something that another school district negotiated, you need to be extra careful, because I've seen it where vendors come out and they start sending them out, right? They send them out to everybody. Hey, we signed this with someone, so it's good. You should sign it. And that's probably true if that district that initially signed it worked with Nicki and me on reviewing the Exhibit H and making sure maybe that if there are other provisions that need to be put in there, that they are. But it may be that other school district didn't have any review of it, really. So I do think we have to be careful about relying on it too much because of that limitation or those experiences.
Yeah, I mean, I think my bottom line would be, and I know that a lot of you are already doing this, which is that if you are either getting a document like as an originating district from a vendor, or you are signing on or piggybacking on to another district, and there's modifications to Exhibit H, like, you need to review them, and we are happy to help you with that. I spend a lot of time these days, and luckily I've reviewed a lot of the Exhibit H's now, and I know Jackie has as well. So we are able to sort of streamline this process, but it is worth 20 minutes of your time, or our time, to take a look at this and say to vendors, listen, we'll agree to this, and this, it's fine, but these two other things are not. And actually, it was really interesting today, Jackie, I was reviewing one for a district where originally in their original Exhibit H, this vendor had put a 30-day, so the Ndpa requires a breach notice to be sent out, I think within 72 or 48 hours, 72 hours, which is good, and most districts want it. And one vendor had changed it to 30 days. And then when I reviewed it again this past time, their new standard Exhibit H now says 5 days, which is a much more reasonable amount of time, and certainly something that this district could agree with. And so we are seeing vendors understanding how districts are responding to some of these Exhibit H's, and we are seeing some changes. But again, I agree with you, Jackie, and I think you do need to be wary of these long amendments. Again, sometimes they are benign and really fine from a legal perspective and a business perspective, and sometimes they really aren't. And so we do want to make sure that you're getting those reviewed by us, by your counselor, by your tech directors, by whomever is looking at these, to make sure you're comfortable with those changes.
Right. And remembering that, just because, like, with the limitations of liability, for example, some districts I work with are much more comfortable with, a limitation of liability than others. And some are like, oh my gosh, I would never, I'm never allowed to sign a contract with language like that. So a lot of it is going to be unique to your district, or to your institution.
Yeah, and I think that's really right. And sometimes, and Jackie was talking about the contract issue, which I think is important to note, because sometimes what the vendors want is they want you to use the limitation of liability or indemnification provisions that are in the underlying service agreement. And so you do have to be aware of what those provisions say, and whether you're in agreement to have them also apply to the data privacy portion of this contract. So
Nicki, we actually did have a question.
Sure. Yeah, I'm happy to answer that. So while we're talking about exhibits, I think it's a great idea. One thing I will also note, and I know you and I had talked about this the other day, which is sometimes vendors are leaving exhibit F blank, which is the data privacy and security, the sort of national standards that they are complying with. They should be checking off what security standards that they are complying with. So just keep an eye on that. Someone in the chat, though, the Q&A, sorry, asked whether someone should be signing Exhibit D. So Exhibit D, for those of you who have not memorized this document yet, like Jackie and I have, is about it's the directive for disposition of data. So typically what I'm seeing is this is, they check it, they fill it out insofar as how the disposition is going to be done, but it wouldn't be signed until it actually, I don't believe that people are signing them until the disposition of data actually occurs, but we can certainly confirm that and send out an update to folks.
And then Nicki, is there like a guide to evaluating SOPA contracts that that people can use? I know that's got to be a question that's on people's minds.
Yeah, I mean, that's a hard question to answer, Jackie. I think, there are obviously some very specific provisions that are required under SOPA in terms of what needs to be in a data sharing contract. And we definitely have a high level overview of SOPA that includes all those elements that we can certainly provide folks. But the complicating fact, of course, is that a lot of these legal provisions sort of intersect and interact, and you have to sort of somewhat be savvy to that way that vendors sort of write these things. I think, again, we're happy to help and happy to navigate through. We are seeing some very consistent changes to the NDPA or to vendor contracts in general under SOPA, and we're happy to help you guys navigate through them. I think, with your ed tech vendors who are savvy to school district needs and requirements, we're seeing really good stuff from them. It's some of these bigger, I think, companies that are a little bit separated from the day-to-day. They're sort of thinking like companies and less like sort of education vendors.
Yeah, let's talk about that a little bit more. So what about those bigger vendors and how DPAs come into play with them?
Yeah, this is such an interesting question. We get a lot of questions about some of the big ticket vendors and how they're reacting to the NDPA. I think some of them are actually being quite responsive. I know, for example, and I'm certainly not going to endorse any particular product, but I will just mention that, for example, we have had very lengthy and very productive negotiations with companies like PowerSchool, where I know they have a lot of Illinois school districts. And so, they had a pretty onerous Exhibit H, which we battled through with them and got to a better place. I know folks have talked about Google. I haven't gotten a recent Google update. I know that folks were going to be working with the LTC, and I probably should have done a shout out at the beginning. And I know someone put in the chat the document from Chris Worley. It is goes without saying that if you have any questions about the mechanics, how to use the NDPA, all of the things, Chris Worley at the LTC is just an unbelievable resource. He's such a good person and so helpful to everybody. And I know he's been holding weekly discussions, and folks should join him. And any questions that they have about who needs to sign what and when and how to use Exhibit E and all of the things, should definitely reach out to Chris. He's been a great resource. But I know that they've been trying to help with some of these bigger vendors. So for some, Jackie, you mentioned this at the beginning, vendors really like this NDPA because they know what it says, right? And so it should be easier to get the NDPA signed from some of these bigger vendors. If you're still getting a lot of pushback, certainly we're happy to help in whatever way we can as well.
Yeah, one thing that Nicki and we've talked about a lot is that right now you're kind of in triage mode, right? Like you should be. if you're not already done, you should probably be in triage mode right now, where you are really working hard to just get your contracts in, a row and in line with the law by the implementation date. And so if the best you can get is a, NDPH that maybe has some terms in it that wouldn't be ideal in the real world, in the normal world. You go for it now to get yourself into compliance, and then you can, renegotiate down the road when those contracts come up for review, and you have a little bit more leverage.
Yes, agreed. And I think, one of the things that I think has been the most complicated about that, and Jackie, I know I am in absolute agreement with you, and folks are sort of coming to me now and saying, we're just starting this compliance process. Absolutely, let's get going, let's get started. Triaging where you share the most student data is really important. I think a general, the first step, and I know you and I have talked about this for years, which is auditing your district to figure out where and how you're sharing student data, and then starting to triage from that list. And one of the things that I think that has become the most difficult for folks under SOPPA is trying to differentiate which operators are actually covered by SOPPA and require DPAs, and which ones are not covered by SOPPA and do not require DPAs. I don't know, Jackie, you're seeing this as well. Where can we start with this conversation with folks?
Yeah, so I think one thing to remember is that applications and websites that aren't designed and marketed for K-12 purposes don't fall under SOPPA. And so you don't need a DPA with those vendors. So that's kind of a place to start, is figuring out, which applications and websites are we using that we think fall under this category of being designed and marketed for K-12 purposes.
Yeah, I think that's right. I think that is a really good place to start. And because we promised sort of the higher level, more complicated discussion of this, I think that one issue that I am seeing with this is that there are the bucket where it's clearly a K-12 operator, you're going to get those DPAs in place, and we can talk a little bit more through that. But one of the things to think about also is when you are looking at those apps that are not specifically designed for K-12, they are not all created equal. And so there are some of those applications and websites that collect a lot of student information. I'm going to give you an example that I am seeing actually in multiple districts, particularly at the high school level, which are fitness apps, right? Fitness apps that are designed for general use, but collect all sorts of information: gender, weight, height, fitness routines, workout, all of the things. Some of these are free, and so getting a DPA is probably going to be next to impossible, if not impossible. They also aren't designed for K-12 purposes, but you really do need to be careful with these. So I was reviewing one for a district, I think it was yesterday, and the first thing that I would suggest that districts do in these circumstances is to make sure that they are reviewing the data privacy policies of these companies. So even if you're not getting a DPA, you're looking at what they've posted online as their data privacy practices and policies. The reason I'm suggesting that is because you need to feel comfortable, if you are using this, that you're comfortable with how the vendor is using and sharing and dealing with your student data. Because you have to keep in mind also that, while SOPPA may not apply, FERPA and ISRA probably do. And so you need to figure out, while you don't need a DPA for FERPA and ISRA, you can't share data just sort of willy-nilly, right? The one that I reviewed yesterday, I just wanted to highlight because actually right in the middle of the privacy policy, it says, we do not recommend this for 16-year-old, for kids under 16 or 16 and under, which really wipes out all of your freshmen and sophomore students, at the high school level. It also was very clear that they sell private information to advertisers, which again is not something that we can do under FERPA, also not a great practice for student information. And so the very first thing you're going to want to do is review even those. If you know this application is not built for K-12 purposes, you may want to get a DPA. If you can't get a DPA, at the very least, you're looking at a privacy policy, and you may need to get parental consent, right? It may be something where you are actually going to need to get consent to share because of the privacy policies. I just think that you want to think about those apps. Even though SOPPA may not be implicated, you have to think about the other privacy concerns that you're facing. But again, there are going to be a lot of vendors like potentially like your cloud storage vendors or others where you really don't need a DPA. They are not designed for K-12 purposes. And as you triage through, putting those in different buckets, I think can be a useful way to think about this problem.
Right. And remember too, if you're dealing with students who are under the age of 13, you also are going to be having to think about COPPA, which requires that you meet some other somewhat similar requirements than SOPA and FERPA and ISRA in order to stand in the place of the parent for signing up a student that sharing information with an online vendor. So I totally agree. It's not as though we're saying, well, if it doesn't apply, if it doesn't fall under SOPA, then you can just do whatever you want, because there are still all of these other laws that come into play.
Yeah, and I do want, I just want to note that our friend at District 99, Rod Russo, who I spent a lot of time talking about data privacy, and I also refer everybody I know to him. So Rod, sorry again for that. And he is noting that they have so many applications that they need to work through. And there's just no way that a lot of districts are going to be 100% compliant by 7/1. And so I think one of the things that he said is so critical. And I do want to back up and talk about it a little bit, which is developing and following a good process. And so he says it's not really a question, but a statement. And I think it's a good one, because one of the things when you're thinking about triaging and going through all of where you're sharing data and all the things, you have to start thinking about how this works with your teachers in the classroom. And we're going to talk a little bit later about teachers and how to think about training. We'll talk about liability if you're not into compliance. But what I want to think about right now is this idea of making sure that the folks in your district are talking to each other about how to think about data sharing and how to sign up for applications going forward. So, when the tech folks, your director of technology or your folks who are in the tech department, they cannot do this alone. And so when they are talking with your curriculum and instruction folks, and when you're setting up processes internal to your district on how to review applications and websites, how to vet them, how to think about whether you need a DPA or not, once you set up those processes internally, this is going to get a lot easier over time. It's like sort of like the big mountain you have to get up right now. Is to get all of these in place. But once you do that, if you have positive and clear processes, you'll be able to do this as time goes on in a much cleaner and simpler way.
Absolutely. I mean, this reminds me a lot of another thing that we work with technology folks on, which is data or website accessibility. And how tough it can feel initially to get your website compliant, but then once you put in place a process where if someone wants to create a new web page, there's at least a notification to the person who has knowledge of what the web design should look like. It actually is super easy, and it takes 20 seconds more than it would have otherwise to set up the website, to run it through and check it to make sure it's accessible. So I think this is really, it's the same idea. And I actually loved a comment. I don't remember if it was Rod or if it was Josh Halverson I watched back in, I think like December, a webinar that you, Nicki, did with Josh and Rod for the DuPage ROE. And there was a comment in there that I stole and have been using. It wasn't you, Nicki, but it was that, look at your budgets, right? I mean, and Rod mentioned that in his comment just now, where are you spending money on these things? Because if you can identify in your technology budget, in your general curriculum budget, in your student services budget, your special education budget, you can see where you're spending money on these types of things. That's an easy way to identify what's out there. And then also, and I know, Nicki, you and I have been talking about this for years too, putting in place something where people can check against a list to see if something that they want to use has already been approved. And if it has, they can go forward. If it hasn't, they know a contact to reach out to in order to get that checked. I'm probably like spoiling us we're probably talking about that somewhere on our outline here, but I just think it's a good point that goes with what you're saying about putting up those processes.
Yeah, no, I mean, I think that's a really good point. I think it's a good thing to talk about right now, because And we're going to talk about, and I think it's interesting because what we want to mention also next, I know you're going to talk about this, Jackie, in a second, is talking about who can sign contracts and who can't. And so that really dovetails with this issue, right? Which is that I think that there was sort of, when ed technology started, there was sort of this wild west of, signing kids up for all sorts of things. And then I think we got a little bit of a handle on that. And then COVID happened and we needed to sign everybody up for every electronic thing in the universe. And so I think, again, we're just reminded always that if you have an internal process where teachers can go through and and get apps approved or see what is already been approved, that's going to make your lives much easier, tech directors' lives in particular, much easier going forward. Really, though, what we're talking about, of course, right now is just getting up that mountain, which is trying to figure this out, where you're sharing data and getting those in places, and trying to parse through where you need a data sharing agreement, where you don't. I will say that when in doubt, if you have something where you feel like you are sharing student data, and maybe it's a K-12, and we'll talk about what covered information means, and maybe it is, or maybe it isn't, and your feeling is that you're sharing data with this vendor and you want a DPA, like, go for it. Like, it's never going to be a bad thing to have a DPA signed. Those may be lower on your list to sort of reach out to, but absolutely, there's no reason you can't get a data sharing agreement, even if someone falls a little bit outside the box of what we're talking about today. So again, I raised about signing contracts. Jackie, what are you seeing here, and what's the best practice?
Yeah, well, and so I do want to say one thing before we go to that, which is in relation to what you just said about, like, if you want a DPA, get a DPA. I think people should also feel comfortable in the other direction, which is to say, if you want to tell your teachers, get parental consent, get the parents to sign the kids up for that before you use it, feel free to do that too. I mean, I know that my kids, they're public school. Most of the apps that we signed up during COVID, I had to go in and sign up and agree that, they could use it. And if I don't agree to that, you do need to come up with some alternative way for that child to still access their education. But most people signed up for it. And if anybody, I felt like that was an easy way, although if anybody comes up with an easy way for me to help my, 6 and 9-year-old remember their passwords for all of these things, I am still taking advice on that. But yeah, I think, you can be creative to do what works for your district as far as how you skin this cat. I don't really love that analogy, but it is a very apt one. I think there are many different ways to get to compliance here.
Yeah, my cat just perked her head up, by the way, not liking that. And I do actually want to raise, so someone asked in the chat, are there companies that are helping districts with sort of SOPPA compliance? So I want to answer that sort of in 3 ways. The first is, of course, we're happy to help with reviewing Exhibit H's, and we'll talk a little bit about other ways that we can help. I do think that there are some companies out there where they're assisting with the element of sort of posting and organizing your DPAs. Obviously, you can post within the LTC and the Ndpa portal, or the Illinois version of the portal, your contracts. But I know that there are some technology vendors out there that are helping folks sort of organize all of their data privacy postings and work. So that, I think, is one element of help. But I'm also, the third thing I'm going to say is I'm going to send that out to the group, because I know we have some tech directors on that are quite familiar with all this. So if there are other resources out there that you think have been super helpful in terms of SOPPA compliance, please go ahead and stick them in the chat, stick them in the queue. Actually, I don't know if they can see them in the chat, but if you guys can see the chat, go ahead. I think you can. If not, we'll read them out.
Yeah, or I can repost them too. So if people share something to all panelists, I'll repost it if it's something that you're sharing for the group.
Yeah, I think they can't see it. So we'll make sure that we get it out to you guys so you can see it. We can also send a follow-up to everybody who's on. And so if you guys have resources, send them our way if you think they're helpful to folks on this call, and we're happy to share them.
Well, and on that point too, I mean, I certainly am. I think it's great when there are companies that come up with shortcuts for, how to find things that find the agreements and the vendors that you need to be entering into DPAs with. I think that's great. But I also think it's important, particularly for smaller districts out there, to know that it's not a requirement. It's it's not essential or necessary in most cases to come into compliance. It's like most things. You can, depending on how much effort you want to put in, you can throw money at the problem and, get somebody else to shortcut it for you. So that is possible here. It's also, again, another analogy to the website accessibility environment, right? Like, you can find a company out there that'll take a ton of money from you to make your website accessible. You can also really do it with minimal legal assistance from your law firm and, some work from your IT team, for much, much less. But it's a question of how much time you want to devote to fixing the problem. And so for those of you who may be like, it's just not in our budget to work with a company to help us locate these contracts, I don't want anyone to feel like that's a necessity. It certainly is not in our experience of working with clients of different sizes.
Yeah, and I would definitely agree with that. And one thing I would just add is that, Jackie, you had mentioned that we would both support the idea of appointing a data privacy officer, which I absolutely agree with. One of the other things that I've seen that's really nice is when districts form a committee to work on this, as just like they do on all the projects, right? You guys are all collaborative folks in school districts. That's sort of your specialty. And so I know that it's been most successful at districts where it is that committee, like I mentioned, where there's someone from curriculum instruction, there's someone from data privacy, there's your data privacy officer, maybe there's someone else who can help with other pieces, and you're looking at this holistically across the district, and you're getting lots of hands on the problem rather than, again, sort of saying to your tech director, like, figure this out. That is going to be difficult to do, and it's not going to be a long-term solution. So I do think districts, as you said, have resources internally, and it's helpful to try to sort of identify those.
Okay, I'll answer your contracts question. Who should sign contracts? I think that was the question. So you need to have a policy in place that says who's going to sign contracts. I mean, the press policy, and I think even our customizations to the press policy leave it pretty vague as far as it being, for example, the superintendent or designee, or if your privacy officer or their designee. So the policy may not give that much true direction, but you do need to think about internally who's actually going to have the authority and kind of where you want the buck to stop. And, I know Nicki has long ago come up with this idea of macro and micro buckets of, when we're talking about these vendors, you've got it's a much easier question when you're talking about macro level vendors who are things like your student information system or your cafeteria, your special education documentation. It's much easier there to say, okay, we're going to have our chief business official sign off on the contracts, or we're going to have our director of technology sign off on these contracts. Where it gets more challenging is when you're dealing with those micro level decisions that are being made, whether it's at the classroom level or the department level or even the school building level. And so it is really important for you to think through, who do you want to be your floodgates to make sure that, that the rules under SOPPA are being followed. And I mentioned earlier that, one option is you vet as many things as you can between now and July 1st, and you tell your staff you shouldn't be using anything if it's not on this list. That puts the onus on them to then, be reaching out. You give them a contact number, contact name to reach out to say, well, actually, I was using this and I'd like to continue using it. Can someone check it? But you do need to communicate to your employees who the buck stops with and who's making these decisions. And I don't know, I feel like that's kind of a non-answer, Nicki, because I didn't say like who should be the person that the buck stops with, but I think it's gonna be different in different districts. Some districts I work with, director of technology is handling this stuff. Some people, chief business officer is handling it. I don't know. What do you think?
Yeah, I know, I agree. I actually just think that what you need to do is internally, there has to be a memo or something, a piece of paper essentially that says, who it is that's designated. And I think it has to be by title. And I would try to keep that list short, but I would not have it be one person. And so if your policy says superintendent or designee, or your policy says data privacy officer or designee, I would have either the superintendent in the former category or your data privacy officer in the latter issue an internal memo that says, these are the people by title that can sign off. So it may be them, it may be the chief business official, it may be the director of technology, there may be a couple of other folks within your district that can do it. And since Jackie brought this up, I think I'm gonna reorder our sort of discussion points and talk a little bit about staff, because I do think that this is another question that I'm getting a lot of, which is, well, our teachers are just like, they wanna sign up for what they wanna sign up for. And it is a big cultural shift, and you have to think about it that way. And I do think that there has to be training of your staff on what SOPA is and why it's important. And I know a lot of districts are sort of starting this conversation, and this sort of dovetails with something Jackie was saying, which is that they're surveying their staff, right? What are you using? I reviewed something that someone sent out the other day, and it was nice because at the beginning of it, they said like, hey, what is SOPA? Why do we care? Like, why do you care? And what are you using in your classroom, and how? And why? And so that's a great way to, again, you're getting the survey and you're starting your teachers thinking about where and how they're sharing data privacy. Then the next step is to make sure that they're trained on the fact that there is now an internal process, or maybe there already has been or always has been, to get things vetted, and that they cannot sign off in the classroom level on anything where they're sharing student information. You know, we're happy to help you with those trainings. You guys can do them internally, making sure your teachers understand, and when in doubt, that they need to ask about, you know, hey, is this an application? It's just my name and, you know, just the teacher's email address. I don't have to vet that, right? Yes, that's fine. You can use that. But hey, I want to use this other thing where I'm signing all my kids up for an account and then they're going to be interacting. Do I need to vet that? Yes, let's go through that process. So I do think that you really, I know the focus right now is on like, we've got to get into compliance. We've got to get into compliance. By all means, we do not want to impede your flow on that. But I do think we need to start thinking about how you introduce this to your staff, your educators, your employees at the ground level, and how you start getting their buy-in. I also get a lot of questions about like, well, what if staff just continue to do it? Obviously, you now have a policy in place. You have disciplinary tools. I'm a huge proponent of the carrot first, you know, why this is so important for data privacy reasons, why your kiddos' data has to be protected. But obviously there are some sticks that you guys have. But I think the first process is obviously training, so.
Right, and try to have some documentation of the communications that you have with employees. This is true not just for SOPA, it's true for all of the trainings that you do, that down the road, if you ever need to show that you complied or that you did your best, it's really good to keep some documentation and really think about the language you use. I mean, I love the idea that you're saying, Nicki, about starting out with some really more, I would say, like normal conversation about what are we even talking about here. And that's one thing I love. I love press. I'm on the press advisory board. I just went through 100 pages just this week of new policies. So I love press, huge fan, love ISB. But a lot of times we will tinker with their policies. And one of the things that, you know, I felt really strongly about, and Nicki and Brian agreed, is that, you know, we needed to couch this SOPA policy a little bit more in the whole realm of the world that we're dealing with. You know, it just sort of like comes in and starts talking about SOPA, but, you know, there's obviously FERPA and ISRA that come into play as well when it comes to student data privacy, just to give a little bit more of an intro in that policy so that if a parent or a community member or a teacher picks it up and reads it, that it really is telling them the story of, you know, why we are complying and what the landscape looks like. So if you're interested in that, you can reach out to us. We have that, you know, ready to go off the shelf with those revisions. So we have been talking about covered information a lot, but I do want to talk about, because I know, Nicki, you've had some questions about the fact that covered information under SOPA doesn't include information that is publicly available, and that people have been asking whether that means that you can release directory information to a vendor without a DPA. So what are your thoughts on that?
Yeah, and I'm gonna really go down the rabbit hole here, guys, so just like bear with me, okay? So you guys all understand that SOPA is implicated when you're sharing or a vendor is generating what is referred to as covered information, which is a long list of all sorts of things about a student and some parent information. So it really is quite a broad list of things. But it says in the definition that it's information, as Jackie said, that is publicly available. It does not include information that is publicly available. Okay, so districts have rightly said, well, okay, but our directory information is something that is publicly available. So does that mean that if all we're sharing is directory information, it is not covered by SOPA? Okay, so let's back up and remind ourselves what directory information is. Directory information it's a concept that exists under FERPA and ISRA, right? It's directory information is information contained in the educational records of your students that would not generally be considered harmful if it was released or disclosed. And so typically it's stuff as names, addresses, telephone listings, sometimes date and place of birth, participate in activities, so someone's on the chess team, and the dates that they are attending. So they are a senior, they attended those 4 years. So some people ask me, well, is there a generic list? No, your district has its own list of what it considers directory information, and it should be in your handbook, it should be in your policies. Okay, so a district is able, they may share directory information to third parties, which if without consent, without parental consent, if it's given public notice, which you probably typically do every year by routine, which identifies, again, what information you consider directory information, and making clear that a parent has a right to opt out of the sharing of directory information. Okay, so what does that all mean for SOPA compliance? What it means is this: it is absolutely the case that we could argue that if all you're sharing with a vendor is directory information that is publicly available, that that relationship does not fall under SOPA. The problem with that is this: if you have any students who have opted out of directory information, you cannot then share that student's information under SOPA with an operator without a DPA. I'm going to say that again and make so that you understand what I'm saying, which is that if the only reason you can share that information without a DPA, why it doesn't fall under SOPA, is because it's already publicly available. But if a parent has opted out of sharing of directory information, that information then is not publicly available for that student, and therefore it would fall under SOPA. What this all means is that for your bigger ticket data sharing items, this directory information, this publicly available thing is just not going to be useful to you. You're going to need to get the DPA. I think the only place this might be relevant is if you have a one-off app in a classroom where you just have like 20 kids using them and none of them have opted out for directory information. Maybe you don't need to get a DPA with that company. I honestly feel like it's going to be more complicated for you guys to try to figure out if this even works for you than to not get the just get the DPAs. But I suppose there could be a circumstance where this would be useful to think about. I think in general, though, the publicly available piece of this is probably not that useful in terms of differentiating between companies you need to get a DPA with and companies you don't. There was a lot of information, so hopefully that all made sense. I know we have a little bit of limited time, so I do want to get to something else, Jackie. I wanted you to take us through this because it sort of dovetails with us a little bit. But one of the other things that SOPA did was it created this whole new section on parent rights, or what the amendment did, right? So now parents have a right to request a review, correct, or delete covered information, which is what we were just talking about. But we also know that we have a whole other way for parents to review, correct, and delete student information under the Illinois School Student Records Act, or ISRA. So how do we make sense of this intersection?
Yeah, I think this is a messy place, and you know how I feel about this. In some ways, I find it positive because to give you again the recap, which we referred to earlier, that ISRA, our state student records law, has always governed personally identifiable information in student records, including in electronic records. And it has always had a process for parents to challenge and review that information. It was always there, and it hasn't gone away. And there wasn't really any effort in this law to reconcile it with the new process that has been created with SOPPA. And so what does that leave us asking? It leaves us asking, is there ever a situation where there would be information that is covered by SOPPA that wouldn't be covered by ISRA? And if so, which process do we use? And my answer to that, which is based on nothing more than my understanding of how we are asked as attorneys to interpret legislation, we're asked to never interpret it in a way that would make something superfluous, unnecessary. And if ISRA always had this process, then my interpretation is that SOPPA would apply to the data, to the content that's not covered by ISRA, so that there would be things that aren't covered by ISRA that are covered by SOPPA. And this works really well for me because I've always been a long proponent of narrowly reading the definition of school student records under ISRA to not include every email that includes a student's initials or, that refers to them by their hair color and their height. To not include every piece of data that a vendor might hold that could identify a student. I've long thought that that was a more reasonable interpretation of ISRA. The problem is that the courts in Illinois haven't addressed the issue. They've never interpreted it for us. We do have federal court cases that interpret FERPA in a narrow way, like would be the reasonable way. So I think in some ways this is an opportunity to maybe rejoice a little that maybe we can take a more narrow reading of ISRA than we may have typically done in the past. And when there is a more onerous process for review and challenge under ISRA, but it would only be applied in those circumstances where we're really dealing with a more narrow subset of records. Otherwise, we have this process where if the information is stored with a vendor, we would use this process to address that. And one really interesting place where that comes into play is with email, right? I mean, most people are using a vendor, a cloud vendor for their emails these days. And so this could potentially be pushing emails into SOPPA and, out of ISRA. But I mean, we are talking to you. We are basically having like a living room chat with you guys right now. We're all around the fire just talking about what we think, because I can't tell you how this is all going to shake out. All I can tell you is that there is some conflict between these two processes, and we do want you to always give the process with greater rights if it's applicable. And so here that is ISRA. So if there is information that falls under a SOPA DPA, but it nonetheless meets the definition under ISRA, we're going to at least want to consider whether you need to give the higher standard of the ISRA process.
Yeah, I think that all makes sense, Jackie. I think it's as clear as mud from the statute. And I think you have done a really nice job of trying to navigate through it. Obviously, when in doubt, we're happy to help. One thing I just want to mention to folks in relation to this is just to remind ourselves that this is also something you need to post is notice about these rights. I know ISB, because I know Jackie was just looking at this, is planning on coming out with an exhibit that has this that you can post. I will also say, just by point of fact, that I drafted something up, which I think is a little bit more, I think I described it as like handbooky language, than the ISB is a little bit more formal. If you want mine, you're welcome to have it. I'm sure ISB will come out with theirs soon, and that works just as well, but it just talks about these different timelines and different processes.
Nicki is being very kind and humble to not tell you all that I emailed her, because that was at the end of the pack. And I said, Nicki, I can't, my eyes are like bleeding reading these 100+ pages of policies. look at this one. So she actually did that review. So thank you for that.
Yeah, absolutely. I do want to, because we have just a few minutes, I want to talk about a couple of things. We talked a little bit about privacy officers. I do want to talk about liability, because people have been like, oh my God, I'm not going to be in full compliance. Is there SOPA jail? Am I going there? There is no SOPA jail. So just as a quick background, this law is enforced by the Attorney General's office. There is no private right to sue a district. Like, a parent can't sue you under SOPA. The Attorney General would have to, presumably they would receive a complaint and they would have to bring an action against a school district. I do not anticipate that if you are working to come into compliance and you don't have every single DPA in place, that the Attorney General is going to walk in your door. So I think that is an unlikely scenario. I do think that you have to think about one other thing, though, which is that while a parent can't sue you under SOPA, if there is a breach of your vendor has a data breach, it is possible that a parent could sue under some sort of tort theory. So you damaged their child in some way. I think it's a difficult lawsuit. You know, what the damages are may be difficult, and you may have tort immunities. But what I will say is that your good faith effort to come into compliance is going to assist you in defending any of those types of lawsuits. So I guess, again, sort of back where we started, which is I would encourage everyone to work as hard as they can to get as many of these in place as they can with that triage approach. If you don't get them all in July 1, just keep working on them, again, with the hope that obviously one of the vendors you don't have a DPA with is not going to get breached. We don't see a lot of breaches in this area. It could happen. We know Pearson was breached. So I think if you're making good faith efforts, I also think if you've got the low hanging fruit done, you've got your policy in place, you've got your parent rights stuff posted, you send out your annual notice using the ISB form. You have, a clear internal designation of who can sign off on these agreements. Get those things in place too, because with that and combined with your efforts on the DPA front, I think you'll be in a good place should anybody try to argue that you haven't come into full compliance on July 1.
Yeah, my guess is my crystal ball prediction is that we're going to see these types of challenges coming up indirectly, where like you said, where there's a breach or where a parent is requesting information from the school district, but that is held with a vendor, and it turns out that there's not an agreement and the vendor doesn't comply, and that may be a circumstance where we see that. I've seen it come up with the Illinois School Student Records Act in that context where someone was asking for records and the school denied the request for this, that, or the other reason, and then they go into court in order to ask the court to require the district to act under the law. So that could potentially be something that, where it comes up.
Yeah, so, and I think just to close out, what I'll say is a couple of things. The first is, if you would, I think Jackie has too, but I've spent a lot of time sitting down with individual districts to talk through their questions and how it looks within their districts. I am more than happy to have individual sessions, I know Jackie is as well, with districts. So if you're out there and you're sort of befuddled and you'd like some assistance, let us know. I will say also that there is a question in the Q&A that I'm not really clear on what the question is. It relates to districts having sort of language and that they'll continue to use Google. If you could just reach out, I'm happy to answer that question. And one-on-one, I'm not sure that we're really clear on what the question is. So happy to do that, happy to answer any individual questions. And like we said at the beginning, we're also happy to look at those Exhibit H's if, when in doubt, you don't know when to sign on. So you are not alone in this process, and we'll do our best to help you in any way that we can. So thank you everybody for joining us. I think we're just at the 1 o'clock mark, so we appreciate it, and good luck with your SOPA compliance road.
Hi, everyone.